Based on a question given for the group assignment, I'll be talking about the issue. So firstly, before getting to know the issue, we have to ask whether K and Mac carried out their fiduciary duties to transpire by acting in the best interest of the company, or whether they acted unreasonably and entered into transactions that put their company at stake. Based on these questions, we can identify the issue, which is, are K and Mac personally liable for the amount owing to the stationery supplier due to reckless trading and incurring obligations that cannot be performed?
So Regulation 1 will be under Section 135, where directors of a company must not agree or cause business of a company being carried out in a manner likely to create a substantial risk of a serious loss to the company's creditors. So the terms likely and substantial has to be given weight in relation to reckless trading. So the risk and the potential advantage has to be considered in order to exercise Section 135. So an objective test of a reasonably prudent director has to be carried out. In this case, Mac & K has carried out a business that creates substantial risk to the company, where they actually knew that they might incur an overdraft funds if the net profit obtained is insufficient to pay their creditors. Yet they still accepted the proposal made by Gabby, which went into liquidation a year later after being in business with Transpire. This was because HITE was unable to pay their bills, and resulting Transpire to suffer cash flow problems in meeting their obligations. This problem became severe when Mac later on placed a large order to the regular supplier, which might result into incurring more debts towards their creditor, despite knowing that they are actually incurring cash flow problems. So hence Mac & K are liable under Section 135 under three considerations, which is firstly causation, where there is a cause and effect of a reckless trading the moment they accepted Gabby's proposal. Secondly, culpability, where the directors of Transpire is sufficiently responsible for negligence to be at fault, as they have the knowledge of the overdraft incurring from the bank and net profit that is insufficient to pay their creditors. And third, duration, which is the time frame after K learned that HITT went insolvent and Mac later on placed a large order from their regular supplier, increasing the risk of not being able to pay their creditors. So a case law that can be taking into an example is Lewis versus Mason, where Section 135 actually focuses not only on directors' belief, but rather on the manner in which a company's business is carried on, and whether that modus operandi creates a substantial risk of serious losses. So this became a paradigm case of reckless trading, as Lewis's has not paid attention to financial affairs of the company. Similarly to Mac & K, they didn't actually pay attention to their financial condition of the company. So in conclusion, Mac & K is liable under Section 135.
Moving on to the second regulation, Section 136 states that a director must not agree to the company incurring an obligation unless the director believes on reasonable grounds on that time that the company will be able to perform the obligation when required. So there are three elements to take into account before claiming for a breach of Section 136 as represented in Peace and Glory case. So the first two are covered. Mac, he was the director of Transpire Limited, and he entered into a transaction with their regular stationery supplier. So for the third element, it states that the defendant needs to believe on reasonable grounds that the company will be able to settle the obligation when required. So moving on to the facts of the case, Transpire Limited received a letter from the liquidator regarding its insolvency. However, K kept this as a secret from Mac. Some might argue that Mac had a reasonable ground to believe that they might be able to perform the obligation when required, since he is left in the dark. However, we must remember that prior to the transaction, K was already worried having to access overdraft funds to pay off creditors and suppliers before the joint venture, but Mac still persuaded K to take on the opportunity. And quoting from BM and CB Jackson case, a reasonable and prudent director will assess whether the company is in the right financial position to pay off debts before incurring an obligation. So therefore, Mac should have done proper analysis and research of Transpire's financial waters before transacting.
In conclusion, we can conclude that both K and Mac are personally liable as they have breached Section 135 and 136, since they have allowed the business to be conducted in a manner that brings risk to the company, and they failed to act as a reasonably prudent director.